Hey everybody, welcome back to the Law and Crime Network. I'm Michael Bryant. This is For the Record. I've got on the set here with me Milton Flores, some other guests coming along as well. But right now we're in day 4 of the Florida case against Ashley MacArthur. And we've been waiting for this witness. Good timing. He showed up at the right time. Well, there it is. That's Dr. Andrea Minyard. You know, she's the one we've been kind of waiting on to give us some of the really gruesome details about the death of Ms. Taylor Wright, the 33-year-old victim in this case. So let's talk about it. I got a whole bunch of folks to chat with here, which I love. Dr. John Huber joins us. He is a forensic psychologist. How are you, doctor?
Great, Michael. Good to be here.
Nice to see you again. We'll always have Long Island in March, where we talked about the memorabilia of various famous murderers like, I don't know, Susan Smith and the underwear she donated to a collector. But that's a different story. Also with me is Ann Bremner, trial attorney. She is in Seattle. Ann, how are you? Good to see you.
Great. Thanks for having me.
Let me start with you, Ann. I mean, we have not seen a gun, so there's no murder weapon. The ME is there to talk about how the victim died, but really in the big scheme of things, there's no dispute that she was killed by a gun. So where does this all fit in the mix?
Well, I mean, it's fine. It's not the strongest case in the universe, although we can talk about all the other circumstantial evidence later and the motive. But in the grand mix of things, do you need to have the firearm itself or the knife or the murder weapon? The answer is clearly no.
Milton, let me ask you, Milton Flores, former prosecutor, JAG officer, and criminal defense attorney. Don't juries want to see the weapon? Don't they want to put it in the hand of the defendant?
Yes, as a prosecutor, I always had to do that. And you also had to try to explain what happened with that weapon, how did the defendant use that weapon. You always try to get some kind of DNA evidence. You always want to have your experts testify as to the meaning of the weapon, how it was used, or even if they have bullets, fragments, whatever it is. You know, how can they tie that bullet to that particular weapon, in this case, the gun?
And we did see one expert suggesting maybe the type of gun it came from, even though not the murder weapon. Quick question for you, John. Dr. John, I'm watching the defendant while they're showing grisly photos, which we spare our audience from looking at. But she's looking at these photos, it seems to me, with no emotion, almost clinically. What do you make of that?
Well, that was one thing that I immediately saw as well, and that disturbs me. You know, I want to see a human emotion, and if somebody is not affected by that's not a very good indication that they're what we would call empathetic. And there may be some anger and hatred and disgust that I think the jury doesn't like to see that in a defendant. I think they're more likely to convict in that kind of situation.
Yeah, you know, and it's not bad enough to see the photos of a generic person, but this was a friend, supposedly. So, yeah, I was stunned to see that. So there you go. That's the common expected defense motion following the state resting in any case. All the state has to do is prove a prima facie case, to prove the elements, just enough that the jury has enough to work with. And if that doesn't happen, then the motion by the defense for in this case, both a mistrial and a judgment of acquittal, you know, it's going nowhere. So the judge denied those motions. We're moving on. What the real question is now is, you know, what's the stopwatch that this judge is going to put on the defense for their case? She wants this thing done by tomorrow. Lots of guests to talk about this right now. Let me talk procedurally first about this with with Milton Flores. You know, I'm a little concerned, I'm a lot concerned that how this judge is injecting her need for speed in this case. Does that concern you?
It does. It does. As a former prosecutor and also as a defense attorney, you never want a judge to rush you during either the presentation by the district attorney's office or as a defense attorney. Obviously, the defense attorney has to make very, very crucial decisions as to whether or not their client is going to testify. In this case, you have the father and son team that they have to make the decision along with the client. So it's very, very important.
I'm feeling the pressure, Milton. I feel it here. So I can imagine these attorneys
It's a good point for appeal.
Of course it is. You know, if you go, well, the judge gave us 82 minutes, you know, total, less than an hour and a half put on our case. That might be an appealable issue. Joining me as well on the Skype system here is Joseph Scott Morgan. Thank you, sir, forensic death investigator. You know, the ME was on, but if you happened to go for a glass of water, you missed it. I know the ME is your favorite witness. Because it's what you do. So in this case, knowing the facts as we know them, knowing that the cause of death was not really in dispute, this is a whodunit, not howdunit, you know, what's your take on such a brief appearance by the ME?
Well, you know, I think one of the things of substance here is the fact that she was Miss Wright's body was so greatly compromised. And we were on together yesterday, Mike, and as I talked about, the environmental conditions in Florida are harsh, to say the very least, because of the climate. She talked about water exposure, how this greatly compromises the state of the body, particularly if you have a body that already has an open injury. And this is going to promote rapid decomposition. Also, the fact that we know from just basic science when we were all school kids that heat speeds things up. And you can say many things about Florida, but Florida is consistently hot. And so this is going to compromise a lot of the evidence. I think a lot of people were looking for perhaps substance DNA evidence, which is very, very fragile and can be compromised in this environment as well. I don't know that we necessarily learned a lot relative to the trajectory of the round. She talked about it having slightly an upward tilt to it, but again, we still haven't answered the fact or the relationship between her and the weapon, that is the victim and the weapon, and what positionality she was in. Was she kneeling? Was she bent over? Or did this woman just shoot her while standing at full extension?
Let me ask Ann Bremner a quick question here about the depth or lack thereof that the prosecution went into with this witness. Now, even though we know it's not a how was it done, wouldn't it have been a great opportunity to kind of hit this jury with some of the gruesomeness, a little more detail, to kind of paint a picture of the pain this person suffered before dying?
Well, absolutely. And we just heard on the motion to dismiss, this is just a circumstantial evidence case. Well, those can be stronger than direct evidence cases because evidence doesn't lie. It just is what it is. So, of course, I think that would have been more helpful. But you think this judge on a clock, is everyone just rushing to the end? I mean, in light of what the judge wants to do, right now we got to be done by Friday.
I know it is. It's really concerning. So if you missed the ME because you had to leave for a comfort break for 5 minutes, I can help you with that. Let's take a listen now to what the ME testified to just a short time ago here. So there's the ME describing almost a watery death because of the moisture there in Florida where Taylor Wright's body was buried. Dr. John Huber, let's look at this from the jury's perspective emotionally. They're taking this in, and to be honest, compared to many cases, this was a piece of cake in terms of what can often be the painful part of the jury's job, looking at the photos, understanding how death occurred. How do you think they got this little nugget and did, what they had to do with it?
Well, I mean, they're going to be shocked, and I think what's going to be the kind of the nail in the coffin for the defense is the lack of any kind of empathy, any kind of reaction from the defendant. It's, I was just watching that again, and I'm just amazed that there was actually no facial change or anything else, and I think that's going to convince the jury.
Yeah, I would think she would either not look at it or have some reaction if she did. Milton Flores, the defense, I guess, gets a chance now. We don't know for sure. They're on the clock. They get a chance to put something on. What would you expect from the defense now?
Well, I definitely would not expect the defendant to testify in this case. I wouldn't want to put her in, especially with the way she's reacting or the way she's in front of this jury. She seems to be the type of person that could be cold and calculated, and I don't want the district attorney's office, the ADA, or the assistant prosecutor to play on that, and she could get hammered on that.
How about you, Ann? What do you think? I personally, of course, for selfish reasons, would love to see her testify.
I know.
But what do you think?
Well, I don't think she should, but it's always one thing that I always talk to juries about if I'm defending a criminal case is the right to testify is the accused. It's not the lawyers, that come in, and it really is going to be up to her. Remember in the Casey Anthony trial, we even had to have a stop in the case for her to kind of be evaluated to look at whether or not she had the capacity to deal with that issue. So this woman is cold and calculating. Does she want to get on the stand against the advice of her lawyers? Will they have to withdraw? If she gets up and testifies falsely, all these kinds of issues. But I don't know what else you're going to have in the defense case. You come back to it's just circumstantial. Maybe you just rest. Save time for the judge. State rest, defense rest, and then argue it. Reasonable doubt.
Certainly, the judge would like that. She doesn't want any delays in the defendant making up her mind as to whether or not to testify. We saw those interview tapes with the cops, though, and this is not a shy defendant. Ashley MacArthur states her opinion, and she's very animated. I would not be surprised to see her lobbying, and of course, it's her choice if she wants to testify. So, okay, let's go back to Dr. John. When you're a family member looking at this unfold, really reliving this the second time, discuss how difficult that might be and how they might handle that.
Oh, well, it's devastating for a family member. I mean, she was a mother, and I'm sure that even her ex-husband is probably very distraught over this, because that's the mother of his child, and then her parents. I mean, and then having this, like you said a minute ago, very cold, calculating demeanor on the defendant, and the history of her having been a crime scene tech and all this. She has that feeling like she knows better. She's smarter than everybody else in the room, and that just rips at their heart. I mean, there's no way their daughter, or the ex-wife and mother could ever speak for herself other than through these autopsy data and photos.
Yeah, I think that cocky attitude definitely came through in the interviews. And remember, these were supposedly friends. So family members of the victim are looking at it in that context. And yeah, this has to be painful for them. Before we take a quick break, let me ask you, Ann, when the defense does whatever they do, is there anything they can do other than put the defendant on? We've already seen a ballistics expert basically negate the gun, and the prosecution did that, I'm sure, to kind of water down what the defense might have put forth on the defendant's behalf. So that's not an issue anymore. Nobody's arguing about that. What else could the defense do if not put the defendant on?
I don't think there is anything else they can do that would be really significant. I think you put the defendant on, and you think that she could be persuasive to a jury, even though she's cold and calculating. Maybe that's a strength. I mean, maybe she's able to be articulate and to explain her way out of this, to explain the way out of the damning evidence that we've seen. But you know what? It is not that strong of a circumstantial case. And a lot of juries, even though the law will say circumstantial evidence, as we know, is as valid as direct evidence, I've seen juries for many years, they'll say, circumstantial evidence, is that enough? That's a danger, but a strength to the defense.
Yeah, and in a lot of cases, in fact, I say the majority are decided on circumstances versus direct evidence. We're going to take a quick break. We're going to come back. The courtroom there is a little quiet. They're on a break. We are waiting to hear whether or not the defense puts on a case. That's where we are now in the Florida case against Ashley MacArthur. Did she kill Taylor Wright with a bullet to the head? An execution, basically. We're going to come back to this case right here on the Law and Crime Network. Stay where you are.